Commentary, she's already out on bond for one crime and decides to go shopping for trouble. Literally. Spoilers. She didn't pay at the register.
Miss Moss appeared before the judge after being caught stealing from a store. During the incident, she was with a juvenile just 15 years old, and they were caught trying to leave with 108.
Commentary, quick legal note: being out on bond is like being on legal probation light. One wrong move and the judge can snatch that bond away faster than you can say, clearance sale.
$86 worth of merchandise. Surveillance footage confirmed the theft. And while the teen tried to ditch the items and run, both were eventually detained. But this wasn't just a simple shoplifting case. It turns out Miss Moss was already out on bond for a separate case.
You were on bond for another case, and now you've picked up a new case. Really, at some point, we're going to just revoke the bonds and make them high. If you're a danger to the public, there's only one place that we have. Good morning, Miss Moss. Ma'am, you were charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Yes, Judge. On February 13th, officers responded to a theft call at the Carters located at 1257 West Bay Area Boulevard. Dispatch advised that one female, the co-defendant, was concealing items in a bag and underneath her sweatshirt, while the other female, the defendant, was handing items. Claiming witness stated that the female.
Commentary, by the way, 186 worth of stolen clothes doesn't sound like much until you realize theft over $100 is enough to turn a slap on the wrist into a charge that sticks on your record like gum on your shoe. What do you think, too harsh or fair game?
Females were walking out of the store past all points of sale. Officers located both females walking out of the store located on the sidewalk next to the store, traveling west on foot. The co-defendant attempted to ditch the
Commentary of danger to the public. That's not a phrase you want on your resume. In court speak, that's basically the judge saying, I don't trust you on the outside.
clothes where she threw them on the ground. Both females were detained. The co-defendant was identified as a juvenile. The complaining witness provided video footage of the theft, and the total of the merchandise stolen was $186.
Okay. Do you have the co-defendant? Do we have it? That person here? Do you know? Do you have a cause number?
It's a juvenile, Judge.
Juvenile.
I believe that they would be in juvenile
Okay.
court.
All right, Ms. Moss, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any Carters. Do you understand? You were on bond for another case, and now you've picked up a new case. Really, at some point, we're going to just revoke the bonds and make them high. If you're a danger to the public, there's only one place that we have. Do you understand, Ms. Moss? Did you want to apply for a court-appointed lawyer, ma'am? Okay. Do you mind filing no going to any Carters, please? And who is the co-defendant? Like, do you have a relation? Because I'm going to order no contact with that person.
Let's see, Judge, if I can find it.
Whatever.
I just have the identifying information, the initials IM. I believe she's 15 years old.
Is there, or did they list a relation of some sort? Do you know?
I don't see it on the danger arm. We don't have the evidence report back yet.
I guess we'll wait and let me see. So for now, ma'am, I'm going to have you sign a receipt with Victoria. I need you to fill out an application for me, and then we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, please. Deputy Manager, would you? Mr. Vieira, you are charged with driving while intoxicated, second offense. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 24th of 2023,
Commentary breath test came back at 133 well over the .028 legal limit. In other words, that's not just a drink with dinner, that's dinner was the drink.
officers observed a dark sedan stopped at the light traveling westbound on Washington Street. And when the light turned green, the officer began to go, and the motor vehicle, a black BMW, almost struck the patrol vehicle on Shepherd Drive, causing the officer to hit the brakes. The motor vehicle then proceeded to drive southbound in North Shepherd, driving down a one-way street. A traffic stop was conducted. The officers approached the vehicle and observed a mild odor of alcoholic beverage coming from the vehicle and an open liquor bottle on the floorboard behind the passenger seat. The defendant was identified as Christopher Vieira. The defendant was observed to have bloodshot eyes, and slurred speech. The defendant stated that he had not been drinking and he was just driving around. As officers were conducting the walk and turn, the defendant stated he had surgery on his foot/leg when he was a baby and that something was wrong. HGN, 6 out of 6 clues, walk and turn, 5 out of 8 clues, and a 1-leg stand, 2 out of 4 clues. During an inventory search, the officers found that open Espolon tequila bottle. The DXP was red and the defendant consented. The breath results were 0.133 and 0.1.
We've had a lot of issues with Mr. Vieira. And this case is now 700 days old. Take a seat for me in the jury box. Let's wait for his lawyer to get here. Good morning, Ms. Wells. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to
Commentary, now we've got a protective order violation in the making, because nothing says breakup etiquette like throwing punches in a wine bottle.
do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 15th, officers were dispatched by the Harris County Transit Authority dispatch to a reckless driver in the 5200 block of South End Houston Tollway. Officers observed the vehicle fail to maintain a single lane and nearly strike 3 different vehicles. A traffic stop was initiated. Officer observed slurred speech and disheveled clothing. The defendant admitted to drinking. SFSTs were performed 6 out of 6 HGN with vertical nystagmus. Officer was not able to conduct the walk and turn in the one-leg stand due to being unable to maintain her balance. Defendant consented to breath, came back as a .296 and .297.
Any prior DWIs? Ms. Wells, I'm going to find that there's probable cause to go forward with the case. Can you run your license as well, please? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume anything, I'm going to revoke your bond and put you in jail. Do you understand?
Yes, sir.
If you have a problem with drugs or alcohol, now is the time to address it, because if it becomes an issue, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand?
Mm-hmm.
It's about the drugs.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, you may not drive. Do you understand?
Mhm.
Okay. Tell me, do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify for an appointed lawyer. If you do, then we'll appoint you someone. For now, I'm going to have you meet with Victoria. We'll have you sign a reset. You'll eventually get with Felicia your bond conditions, and then Deputy Miranda will give you an application. Are you Miss Andre?
Yes.
Miss Andre, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 16th, officers were dispatched to a disturbance in Harris County, Texas. Officer made contact with the complaining witness who stated that he and the defendant had been in a 2-year dating relationship. The complaining witness stated that he broke up with the defendant and was trying to kick her out of the apartment. And the complaining witness was trying to force her out. The defendant punched him several times in the body, bit him, and broke a wine bottle on his head. The officer observed an open wound on the complainant's head and bite marks.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate that protective order, the state can and will file a violation of protective order against you. Now's not the time to fight your case. I mean, if you need a lawyer, we can help you with that. Otherwise, you can go hire a lawyer and speak to them and they can help you fight the case. Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am?
Yeah.
I'll have you fill out an application. I'll take a look at it. Hold on.
I'm sorry, I thought you were saying-
I'm issuing bond conditions on you now. You're not to have any contact. You're not to have any contact with this person. And I don't want you to have any weapons. If I find that you're a danger to my public, I'm going to revoke your bond and put you in jail. Do you understand? Okay, Deputy Miranda, do you mind? Okay, I'll have you sign a reset and then we'll have you take a seat in the jury box.